Ms Scott, and I'm going to remind you, because you're quite soft-spoken, to keep up your voice as much as possible. Please.
Yes, of course. I'm sorry. I'm having a bit of trouble with my voice today.
Well,
so
we
I
must
apologise.
make all manner of alliances. How come you've got water there? Is there anything else we can
no,
supply to help you?
Thank you very much. I'm fine.
Okay.
Soldier on.
Good.
My Lord, I'll deal first with the point that you raised, Lord, before the adjournment in relation to Bickle.
Yes.
And whether or not the formulation that is used by Lord Justice Roskill in West Leighton is a true reflection of what was said in Bickle.
Yes.
And it is entirely fair to say, as my Lord pointed out, that the way that it's put by Lord Justice Roskill is not how it was put in Bickle. So it's not, there's no express statement by Lord Denning in Bickle that one must look at the purposes of the covenant. That is entirely fair to say. However, in our submission, in this case, there is simply an issue of construction that arises, and therefore, whether or not one is looking at it from through the prism of looking at the purpose of the clause, looking at derogation from grant, looking at collateral advantage, one is grappling with the interaction between clauses 311 and 319, and one of those has to yield. That is the issue of construction. So that's why we...
Sorry, the issue of construction is which one has to yield
Which
to the
one
other.
has to yield, my lord?
Why does either have to yield to the other?
Well, I suppose from the way that both Mr. Rainey and myself are putting the case, I'm saying, well, Mr. Rainey is saying there's no hierarchy of covenants, but in fact, his case is that there is a hierarchy because he says clause 319 must prevail. Reasonable means reasonable, like Brexit means Brexit. Reasonable means reasonable. How are we to construe what reasonableness is? We say one must look at the other terms of the lease, and this is where looking at the purpose of the clause and the construction of the lease comes in. So we say reasonableness has to be looked at by construing the other covenants in the lease. And if it's not possible to construe clause 311 and 319 so that one doesn't yield, then one must fall back on the principles of contractual construction, which is what we seek to do. So we're relying on derogation from grant as a principle of contractual construction. We rely on other general principles such as the specific not yielding to the general. So it may be that it can't be avoided that one of these covenants has to yield, and in our submission it must surely be the more general provision which includes the word reasonable, and that has to be construed by looking at the background context and the terms of the lease itself.
I wonder if it is necessary for one to yield to the other. I mean, let us say that the tenant wanted to convert one floor to residential, and that would not give rise to any threat of enfranchisement. If the landlord were to say, I don't want you to do this because I don't want that floor to be used as residential, then one might say that wasn't reasonable, standing the terms of clause 3.11.
Yes, my lord.
If you were to say that I don't want you to do this because it could give rise to enfranchisement, again, that might be unreasonable if there was no threat at all of that. But if the tenant was wanting to convert so much of the premises into residential that it gave rise to this risk of the loss of the reversion, why would that necessarily involve one clause yielding to the other?
My lord, have I understood your point correctly, that you're saying that clause 319 doesn't yield, clause 311 doesn't yield in those circumstances? But what is being sought by the landlord to do in those circumstances is to deny...
What I'm saying is the objection isn't simply that it is residential. The objection is the landlord's interest that's being protected is the threat of enfranchisement because of the extent of the residential conversion.
Yes, well, my lord, we say that the objection is simply that it is that we are seeking to use it for residential purposes. Now, as a corollary of that enables us to enfranchise. But the objection that is being taken is to residential use per se. The consequence of that may be that we're able to enfranchise, but the actual objection relates to residential use. So we say that in those circumstances, that is to cut down the grant of residential use that's been specifically permitted under clause 311. So, my lord, with your permission, I'm going to take you to Bromley Park first, just to let you know where I'm going. I'm going to Bromley Park, then I'm going to international drilling, and then Ashworth Fraser.
Thank you.
So, my lords, Bromley Park is at tab 4 of Authorities Volume 1. I'd ask you to pick it up, please, at page 386 of the electronic bundle, and that's page 58 of the hard copy. So, my lords, just a recap on the facts of Bromley Park. The tenant's occupying a residential flat above a restaurant that's separately let, and she wants to assign, and the landlord is refusing on the basis that it wasn't their policy to permit assignment, and she had to surrender if she wanted to vacate. Now, the evidence at trial was that the landlord was considering granting a lease of the whole building to the restaurant tenant. And the judge took the view that the landlord was reasonable, and he did so relying on a statement in Woodfall at the time that a landlord might reasonably be influenced in his decision to refuse consent by considerations of proper estate management of the wider estate. Now, what happened in the Court of Appeal in Bromley Park was that the judges accepted the tenant's submission that that passage in Woodfall was expressed too widely. And so if I could ask you to look at page 386, electronic, page 58 of the hard copy, about halfway down the page, at paragraph little d, it's recording the submission of Mr. Sedley that the statement in Woodfall is too wide. And then he cites the statement which I've just quoted and goes on to say, Mr. Sedley accepts that the landlord had only to consider his own interests in pursuing those interests. He may withhold consent if by giving his consent he apprehends that he will cause detriment to the interest granted or reserved to him by the lease. It's admitted that the landlord is unreasonable if he withholds consent in order to obtain a new advantage, which he doesn't enjoy under the lease. And the judge, Mr. Sedley said, was wrong because the advantage that he found to have been proved was quite outside the interest granted or reserved by the lease. So the landlord only has to consider his own interests, that's correct, but the landlord can be unreasonable if he withholds consent in order to obtain a new advantage which he doesn't enjoy under the lease. That's the submission that's being made, and that was accepted. And the passage to which I was referring just before the adjournment comes at page 392 of the electronic bundle, page 64 of the hard copy bundle. Sorry, this is where the judges are dealing with the statement in Woodfall. So in the middle of the page at D, Lord Justice Cumming-Bruce says,
I'm so sorry.
I'm sorry.
392 is the end of Lord Justice Dunn and the beginning of Lord Justice Slade.
I think
sorry,
you mean
yes,
page 62.
I'm so sorry, I'm on the wrong
2 pages before.
You're quite right, I'm so sorry. I'm on
That's
the wrong
right.
page. Yes. So at the top of page 392, page 64, Lord Justice Cumming-Bruce says...
64?
64.
62 it should be.
No, Is the very top of the page, or is this the penultimate paragraph of his judgment?
Aren't we referring to Woodfall,
Yes,
which is dealt with by Lord Justice Cumming-Bruce at page 62 of the hard copy?
Yeah,
I
yes,
assume 2 pages before.
which is 390.
390.
yes.
D.
Thank you.
So I'm so sorry. It is page 62,
0. Yeah.
page 390. In the middle of the page, Lord Justice Cumming-Bruce says, I would therefore hold the statement in Woodfall is misleading, and its reference to good estate management as a valid reason for withholding consent is entirely altogether too wide. It does not represent the true effect of the judgments in the cases to which he's referred. And Lord Justice Dunn agrees with that over the page at page 63 or page 391 in the electronic bundle. Between C and D, I agree with Lord Justice Cumming-Bruce that the passage in Woodfall states the law too widely. The cases cited in support of the proposition as stated by Woodfall show that although the question of unreasonableness depends on all the circumstances of the case, including considerations of proper estate management, in no case has it been held reasonable for a landlord to refuse consent for the purpose of destroying the lease in question or merging it with another lease. And then this is the passage I was referring to just before the break, over the page at page 64, page 392. This is a formulation of the no uncovenanted advantage principle on which we rely, and as I'm going to come on to show, was the basis for Lord Justice Balcomb's second proposition in international drilling. So at the top of page 64, page 392, there's nothing in the cases to indicate that the landlord was entitled to refuse his consent in order to acquire a commercial benefit for himself by putting into effect proposals outside the contemplation of the lease under consideration, and to replace the contractual relations created by the lease by some alternative arrangements more advantageous to the landlord, even though this would have been in accordance with good estate management. So,
Of course, Mr. Rainey says he's not trying to do that. He says he's not trying to replace the contractual relations with something more advantageous. He says, I'm defending the status quo.
yes. Now, on Mr. Rainey's case, the status quo must remain from the beginning of the lease to the end of the lease. His proposition is that this is a 100-year lease and it's to be ossified from the outset because the tenant should not be able to take advantage of provisions which enable it to change use, for example, throughout the term, if to do so might harm the interests of the landlord. And we say that that isn't correct. And what is being sought to do here is to vary the terms of Clause 311, which specifically grants the right to use for residential purposes. And Mr. Rainey's client's objection is specifically that it doesn't wish there to be residential use because it will cause it harm. And we say that that is not sufficient. Harm is not a sufficient condition.
Yes.
So, my lords, could I ask you please to turn to international drilling, which is at tab 6 of the authorities bundle. So we rely on international drilling, if it's necessary to do so, to illustrate that the principle of no uncovenanted advantage isn't confined to cases where the landlord seeks to force a surrender of the lease, for example. It can encompass cases where, as we say here, the landlord is in effect seeking to vary the terms of the lease, so seeking to do something that will affect the landlord and tenant relationship internally to the lease. A surrender might be something that's external, but affecting the relationship of landlord and tenant internally would be to vary the terms of the lease by the back door, we would say. And international drilling is an example of the court finding that the landlord is unreasonable in refusing consent to an assignment on grounds of use, the use to which the proposed assignee wanted to make the premises, where that use falls within the permitted use. So Lord Justice Bolcombe was there not following his own fifth proposition on the facts of the case before him.
But there are some dicta here which struck me this morning when Mr. Rainey was referring to it, which seem to be in his favour. And if you've got page 91 open,
I do,
and
my
if you
lord.
could go to B, between B and C, we see the Lord Justice saying there's all the difference in the world between the case where the user clause prohibits only certain types of use, so the tenant is free to use the property in any other way, and the case where, as here, only one specific type of use is permitted. So what do you say about that, Ms. Scott?
Well, my lord, we say that there is a difference, indeed, between prohibiting only certain types of use and specifically permitting particular types of use. And we say we fall within the latter, because we have a case here where specific uses are granted. I've already touched on the point that it's expressed in negative terms, but in our submission, looking at the matter commercially rather than as a matter of linguistics, it must be the case that what is being done here is granting a specific use. And so there is a difference between prohibiting only certain types of use and specifically permitting uses. And we say that that is one of the reasons why we fall within a derogation from grant principle. Now, Lord Justice Bolcombe didn't express his conclusion in international drilling in terms of derogation from grant, although if one looks at the submission that was made by Mr. Morgan QC, going back a couple of pages to page 87 in the hard copy bundle.
Can you give me either an electronic or a law report page?
I will. The law report page is 519, my
That's
lord.
fine, thank you.
So at F is recorded the submission that was made. Mr. Morgan submitted below and renewed by his respondent's notice this submission that since the proposed use of the property was not forbidden by the lease, the landlords, by refusing consent to the proposed assignment, were trying to secure a collateral advantage in the form of preventing a use which was originally permitted when the lease was granted. Now that could have been formulated as a derogation from grant type case, but it wasn't. But in our submission, that doesn't matter. So Lord Justice Bolcombe's second reason, this reason for finding for the tenants, was in our submission accepting the tenant's argument that preventing a use that was originally permitted would be to secure a collateral advantage, although it wasn't expressly formulated in that way. And in our submission, if it can be reasonable to refuse consent where the proposed use falls within the permitted use, so the permitted use was office use, that was a wide, if we call it a wide use, what was being sought to do by the proposed assignee was to use it as serviced offices, so that's within that wide permitted use. So although there was only one single use, there were ways of carving it up, if you like. And Lord Justice Bolcombe was saying, well, it was unreasonable to refuse consent in those circumstances, even where you're only refusing consent to one part of the express use. And we say here we're on stronger ground than that, because what the appellant's seeking to do is to deny the proposed use, the residential use, the permitted use, that is the only permitted use. We're not carving up here particular types of residential use in the way that office use is being carved up in international drilling. Now, it's entirely fair to say that there are 4 other uses that are permitted under the user clause. So it's undoubtedly the case that those remain for the time being, but we say that doesn't affect the point of principle, specifically the point about derogation from grant, this rule of common honesty, the rule of fair dealing, the independent rule of law, this derogation from grant point. There may be other uses that remain available, but there are 5 specific uses that have been granted, and there's no hierarchy one of them shouldn't just be made redundant. How would one choose which of those 5 uses is expendable? We say they're not cumulative, they're not sort of numerical, they're all individual uses that are equally as important as each other. And we say to take away just one of those uses and negate it entirely would be to deprive the tenant of enjoyment of that use and would therefore to be a derogation from grant. Just in support of that submission, my lords, I would point back to Cabras, which I won't take you to, but I will make the point. The user covenant in Cabras permitted a change of use. So although the use of the betting shop was the only permitted use, it was possible for the tenant to seek the landlord's consent to a change of use. So although it looks like a singular case, in fact, other uses may have been permitted. But the Court of Appeal didn't consider that that affected the analysis. The analysis being that it was a derogation from grant to prevent the tenant from being able to advertise that specific use on the outside of the premises. So, my lords, I was just dealing with international drilling. And I was making the point that we rely on this case to illustrate that the principle of no uncovenanted advantage isn't simply confined to cases where the landlord's trying to force a surrender of the premises. It can encompass the sort of case that we're dealing with here. And we say that, importantly, in international drilling, the assignment clause, so the clause that contains the provision, the consent provision, was construed to yield to the user covenant. The consent provision wasn't construed so as to cut down the user covenant. It was the assignment, the consent provision had to yield, that the tenant should be allowed to assign to somebody who could use the premises for the permitted purposes. My lords, could I ask you please to look at the propositions of law that were set out by Lord Justice Bulcombe, and in particular proposition 2, so it's page 88 of the hard copy bundle and 416 of the electronic bundle. So proposition 2, which corresponds to Ashworth-Fraser's first overriding principle, is expressed in this way at the top of the page. As a corollary to the first proposition being to look at the purpose of the covenant, specifically the purpose of a covenant against assignment in this particular case. So proposition 2, a landlord is not entitled to refuse his consent to an assignment on grounds which have nothing whatever to do with the relationship of landlord and tenant in regard to the subject matter of the lease. And that's the formulation that's used in Ashworth-Fraser. But what Lord Justice Bulcombe goes on to say is a recent example of a case where landlord's consent was unreasonably withheld because refusal was designed to achieve a collateral purpose unconnected with the terms of the lease was Bromley Park Garden Limited and Moss. And as I've already explained, we rely on the formulation in Bromley Park, Garden and Moss as expressing the proposition that where the landlord was trying to do something like vary the terms of the lease internally, as between landlord and tenant, that can amount to a collateral purpose. My lords, would you also please look at proposition 6? So that's a little bit further down the page, page 88 or page 416. So Lord Justice Bulcombe here is considering the question whether the court should have regard to the consequences for the tenant if consent is withheld, and he concludes that it should. Now, in our submission, proposition 6 bears some similarities to the derogation from grant argument that we're raising before the court. So Lord Justice Bolcombe refers at letter G to the case of Leeward Securities. That was concerning a subletting in the context of the Rent Act. And he says there, both Lord Justice Oliver and Lord Justice O'Connor made it clear in their judgments that they could envisage circumstances in which it might be unreasonable to refuse consent to an underletting if the result would be that there was no way in which the tenant could reasonably exploit the premises except by creating a tenancy to which Rent Act protection would apply and which inevitably would affect the value of the landlord's reversion. So in other words, it was recognised as being unreasonable to refuse consent on the ground that the assignee would have Rent Act protection if the landlord was effectively making the property inalienable, because all potential assignees would have Rent Act protection. And Lord Justice Bolcombe quotes from Leeward Securities at the top of page 89 or page 417. He says, quoting, "It mustn't be thought that because the introduction of a Rent Act tenant inevitably has an adverse effect upon the value of the reversion, that is a sufficient ground for the landlord to say that they can withhold consent, and the court would hold that that is reasonable." So that supports our submission that harm to the landlord is not a sufficient ground for refusing consent.
Excuse me, where was the passage you've just read?
That was at the
Top of
the top
page
of page
89.
top of page
521.
89, page 417 in the electronic bundle, my
Thank you so
lady.
much. That's not forward.
But I mean, the conclusion of all that is that the principle is, as stated on page 89C to D,
Yes,
there may be cases where there's such a disproportion between the benefit to the landlord and the detriment to the tenant,
yes.
and withholds consent to make it unreasonable. But that's not this case, is it? I mean, you're not suggesting that this case comes within that proposition.
No, I don't go so far as to say that, my lord. The point that I'm seeking to draw is that disproportionate detriment to the tenant can arise where the landlord refuses consent with the result that it's going to be substantially deprived of the benefit of other rights granted in the lease. So we don't say that we fall within this particular proposition, but it does come close to expressing something like the derogation from grant principle. And we can see that some of these propositions do trespass upon what we might call the derogation from grant principle, because where
I
you've
mean, whether you call it derogation from grant or disproportionality, you don't fall within it. So where does that take you?
I'm sorry?
Now, I don't understand how it helps you. I mean, if you don't fall within this proposition, then whether you change its name doesn't bring you within it.
Yes, my lord. I'm seeking to draw out the point that I just made, but also that harm to the landlord is not sufficient, and that comes from Proposition 2 as well as Proposition 6. So the landlord has to go further than just saying, I'm going to have if I grant consent to residential use, I'm exposing myself to the risk of an enfranchisement claim being made. Now, that may be very serious harm, depending on which way you look at it, but that's never going to be enough in our submission. And that's bolstered not just by the collateral advantage point, but also by Proposition 6.
Harm to the landlord, never enough.
Never enough, my lord. One has to look at...
But, I mean, look at the bit that Lord Falmouth was referring to between C and D, where Lord Justice Balcombe summarises his sixth proposition.
Yes.
While a landlord need usually only consider his own relevant interests, there may be cases where there's such disproportion that you fold in detriment to the tenant. So how can your proposition, harm to the landlord, never enough, coexist with Lord Justice Balcombe's summation?
Because, my lord, I would point to the words or the sentence just before that says the dicta on which he's relying there have to be qualified, because a landlord's interests that are collateral to the purposes of the lease are ineligible for consideration. So it's got to be landlord's relevant interests. I think that's the point that Lord Justice Balcombe is making. One only looks at if it's a relevant interest that the landlord is seeking to protect.
That's Proposition 2. That's a reference back to Proposition
It is,
2.
yes.
Lord Wilson's point is Proposition 6 starts with the question whether it's permissible in certain circumstances to consider the consequences for the tenant, and concludes, well, if there is a serious disproportion of the benefit to the landlord as against the disbenefit to the tenant, then in those circumstances you can weigh up that in the assessment of reasonableness.
Yes.
I don't think 6 is saying any more than that.
Yes. Well, my lord, perhaps I can just move on to say how that plays into the conclusion that was reached by Lord Justice Bolcombe. So we see at G, at the bottom of the page, that the first basis for his decision is that the judge at first instance was right, because although he didn't express it in terms of disproportionate harm, he clearly recognised that there was going to be a serious detriment to the tenant if serviced office use was not going to be permitted. And so he agrees with the judge at first instance there, and then he goes on to rely on further grounds. So if one looks at over the page at page 90, at paragraph D, picking it up at the paragraph that starts, I'm also satisfied that the judge could and should have had regard to the fact that the proposed service office user was within the only form of user permitted by the lease. I've already stated the proposition of law derived from the cases that it may be reasonable for the landlord to refuse consent to an assignment on the grounds of a proposed user, even though that's permitted by the lease. But it doesn't follow that in all circumstances it would be reasonable for the landlord to object to a proposed user which is not forbidden by the lease. In most of the cases cited to us, in which it was held reasonable to object to proposed user, even though not forbidden, the user clause was in general terms merely prohibiting the carrying on of a noxious or offensive trade or business. So this is the point that we were addressing a moment ago. Is there a difference between specifically permitting something and merely forbidding something? And Lord Justice Bolcombe is saying, yes, there is a difference.
Well, is he talking about the language or is he talking about the substance? You could read it like that, but you could also read it in terms of saying it was just a wide user clause with plenty of alternatives within which to choose.
Yes. Yes, that may be the point that he's making. We're going to come on to consider Iqbal in a moment, from which I would seek to draw a similar proposition. But, my lords, the passage which we've already looked at the top of page 523 is where Lord Justice Bolcombe says at B, there is all the difference in the world between a case where the user clause prohibits only certain types of use, so tenants free to use the property in any other way, and a case like this where only one specific type of use is permitted. So he is seeking to draw a distinction there between prohibiting certain types of use, but on the other hand, expressly permitting certain types of use.
You might go further and say, in this case, of course, your aspiration is to use both first and second floors for residence. But if you just asked to use one, the landlord might be in a much weaker position to object, because he wouldn't get up to 52% for the 1967 Act purposes. So you can't say that your user clause is a dead letter, necessarily. It's the particular aspiration that you've got to add to residence on third and fourth, residence on first and second, which gets to 52.
Yes, my lord. I think we'd have to ask Mr. Rainey whether on his case he would accept the proposition that if we were to apply only to use one of the floors for residential use, it would, I suspect he would say it would still be open to his client, and his client would want to refuse permission because it does take us a step closer to
Well,
enfranchising.
I mean, we can ask Mr. Rainey for his comments. They might be very valuable, but we might have our own view.
Yes, of course. So your point, I think, my lord, that you're making is that it's not a dead letter, clause 311, because we may still use one more of the floors, the 6 floors in
Well,
the premises.
I've thrown that
for
out for
residential
your
use.
consideration.
Yes. Well, my lord, I'd make the point that I made a moment ago, that we have been given permission to use the whole of the premises,
Yes.
or any part thereof, for
Understood.
any of the 5 uses, and to cut down and to leave us with an exiguous use within residential uses in our submission would amount to a derogation from grant and would be unreasonable.
Yes. I think you said you wanted to go next to Ashworth.
Ashworth Fraser, yes,
Yes.
my lord, please, thank you.
Well.
It is the first authorities volume at tab 1. So, my lord, I'd ask you to look at pages 7 and 8 in the hard copy bundle. I think that's page 335 and 336 in the electronic bundle. So, just to be clear about Ashworth Fraser, this was a case where the landlord considered that the proposed assignment might lead to a breach of the user covenant. And the court concluded that where that was so, it would be unusual for a refusal of consent to be unreasonable. And I would draw your lordship's attention, please, to paragraph 6 of Lord Bingham's judgment. So the House of Lords overruled the decision in Killick, which went the other way on the question of whether objection on the ground of a breach of user covenant would be reasonable. And I'd ask you to pick it up, please, at Lord Bingham's statement between paragraphs F and G of paragraph 6. Now, what Lord Bingham says is that the decision of the Court of Appeal gave quite inadequate weight to the user covenant in a lease. The lease is, after all, the contract between the landlord and the tenant, a contract with special characteristics and subject to special rules, but a contract all the same. It records what the parties respectively agree to do and not to do. Unless a term is discharged or consensually varied or revoked, a party is ordinarily bound by what he's agreed, even if, with the benefit of hindsight, he regrets his bargain. The contract, as civil lawyers put it, is the law between the parties, and it would rarely be right to hold that a landlord was unreasonable in withholding consent to an assignment which, in his reasonable judgment, might lead to a breach of covenant. So both parties, landlord and tenant, are bound by what they've agreed as to the terms of the user clause. Lord Bingham's saying it would generally be reasonable to refuse consent if there's an anticipation that there'll be a breach of the user clause. And we say the present case is somewhat the converse to that. The tenant wants to use the premises for the expressly permitted use, but the landlord objects to that purpose per se. It objects to residential use. So the landlord's founding its objection on the grounds of a change to residential use when there is no provision in the user clause to enable it to object to a change of use. And this refusal of consent would knock out, it would entirely negate that use for the foreseeable future. And in our submission, it would be unusual for a refusal of consent to be found reasonable in those circumstances. My lords, I'd ask you next to look at Iqbal and Thakrar, please, which is at tab 7. And the paragraph I'm going to go to is on page 94 of the hard copy, page 422 of the electronic bundle. So it's at the top of page 94 or page 422 on the right-hand side between G and H. This is where Lord Justice Peter Gibson is referring to the 5th proposition from international drilling, and he expresses it in this way. It might be reasonable for the landlord to refuse consent to an alteration or addition to be made for the purposes of converting the premises to a proposed use, even if not forbidden by the lease. but whether such refusal would be reasonable or unreasonable will depend on all the circumstances. For example, it might be unreasonable if the proposed use was a permitted use. So in our submission, he may be drawing a distinction there between a use that's not forbidden and a use that's permitted. So it might be unreasonable if the proposed use was permitted and the intention of the tenant in acquiring the premises to use them for that purpose was known to the freeholder when the freeholder acquired the freehold. So, my lords, this is an example that Lord Justice Peter Gibson is making, but the example, of course, is in fact the facts of Iqbal itself. The premises in Iqbal had been advertised by the landlord's predecessor as being for rent with restaurant use, and it was said to be unreasonable, therefore, to refuse consent to alter the premises to accommodate that use. And we say that's similar to our case. In fact, our case is rather stronger than that. We have here residential use that's specifically negotiated between the landlord and the tenant at the outset of the lease. So the premises aren't simply advertised as being available for that use. There's a contract between landlord and tenant that's negotiated that residential use will be permitted. And we say in those circumstances, the parties must have contemplated that the tenant, having negotiated this residential use, or an assignee during the 100-year term, any of those tenants would wish to use the premises for the specifically negotiated purpose. My lords, I would also draw your attention to paragraph 42, which is over the page 95, or page 423 of the electronic bundle. Lord Justice Peter Gibson is recording the facts that were found at first instance, and he says, the recorder, having accepted that the proposed use of the demised premises would depress rents or quicken the turnover of the tenants, it was said that she was wrong to find the appellant's objection on this ground unreasonable. And the judge says, I can deal with that point shortly. Although I accept the fact that the proposed use as an Indian restaurant was a use that was not prohibited by the terms of the lease, that doesn't preclude a landlord from reasonably refusing consent to alterations used for the purpose, made for the purpose of that use. However, I see no answer to the point that is taken by the recorder in paragraph 34 of her judgment, that it was unreasonable of the appellants to object on that ground, the demised premises having been sold with Class A3 use, and that use having been confirmed by the District Council. When that is coupled with the fact that the appellants appear to have been aware at all times that the proposed use, that was the proposed use that the respondents had intended. So here we have a case where it's accepted that the landlord will suffer harm. It's going to depress rents if the tenant is able to do what it wants to do. But paragraph 42 is clear that the landlord can't, in those circumstances, object to the use, even though it will suffer harm, because the premises have specifically been advertised for sale with that permitted use. And as I say, we very much fall within that formulation. Residential use here was specifically negotiated. It's going to be negated by a refusal of consent, and in our submission, that's unreasonable. My lords, I'm going to come on now to look at clause 319 in the wider context. So looking at the other clauses of the lease, clause 315 in particular, and the statutory in the factual context. Now, Mr. Rainey took your lordships to clause 315 of the lease. I don't know if you would like me to take you back to it. This is the clause that carves out specific...
We remember that. We don't want to go there unless you've got a specific point to make.
Thank you. The broad point that I wish to make is that Clause 315 sets out a number of provisions that cut down the rights of the tenant so far as user is concerned, but they show that where the landlord wants to do that, it does so expressly by a clause. It spells it out expressly by a separate clause in the lease, cutting down the user that's expressly granted in clause 311. We say that's relevant to construing clause 319. 319 doesn't contain such an express carve-out, and where that's already occurred under clause 315, in our submission, clause 319 can't be deployed to the same effect. My Lords, as for the wider statutory and factual context, in our submission, these support our case that clause 319 wasn't intended to be used for the purpose of refusing consent to a change to residential use. Specifically, a change to residential use that would give rise to enfranchisement prospects. It was contemplated at the grant of this lease that statutory rights could be acquired by a qualifying tenant under the Act, using the property for one of the permitted purposes. The lease was entered into in 1986. Obviously, that's after the 1967 Act. It's also after a significant amendment had been made to it in 1974, relating to rateable values, and a further amendment in 1980, which reduced the residence requirement. So a qualifying tenant after 1980 only had to be in residence for 3 years instead of 5 years. So you have the Act being passed and then successive amendments to it. And we say the landlord and the tenant in this situation must have contemplated that there might be further changes to the Act. But specifically, if they wanted to prevent the tenant from taking steps to bring itself closer to enfranchisement, they would have made further provision to preclude that in the lease. The landlord would not have relied solely on clause 319 for that purpose. My Lords, we set out a paragraph...
But how over a lease of this duration could a landlord formulate the user clause in such a way as to protect himself against enfranchisement without knowing what subsequent changes statute or Parliament might make to the relevant conditions?
Yes. My Lord, first of all, the landlord could have excluded or limited residential use. They could have excluded it altogether, save for the floors that were already being used for residential purposes. They could have limited residential use expressly from the outset. They could have drafted the covenant so that it was a qualified covenant, so that there could be a change of use, potentially to residential use, but the landlord could withhold consent arbitrarily under a qualified covenant rather than a fully qualified covenant. They could have, in fact, inserted a precondition, because it's possible to have a precondition to a consent provision. So before the landlord has to consider your application for consent, you have to get over the first hurdle of satisfying this precondition. So it could have been said that the landlord wouldn't be obliged to consider an application for change to residential use, or if that were to bring the premises within the Act. That might be something they would have contemplated.
Can you do that? Doesn't the tenant have a right to take certain steps unless he can show the landlord is unreasonably refusing to cooperate?
Under the 1967 Act, does the landlord...
No,
the tenant,
generally under landlord and tenant law.
Well, if the parties can expressly provide within the terms of their contract that there should be a precondition. So you can apply for change of use, but the landlord's not obliged to consider an application for change of use to residential use if that's going to bring the premises within the 1967 Act. There could have been something that the parties could have negotiated.
Specifically that, even if that would not have constituted a reasonable refusal of consent.
Well, yes, because then we're looking at it as a precondition. Rather than trying to stipulate what is a reasonable ground, it's the first hurdle you get over before the landlord even has to consider your application for consent. So reasonableness doesn't come into it in our submission. You've got to get over that first hurdle first. So, yeah, there were steps that could have been taken, my lord, either to exclude or to limit residential use, or to require there to be a change of use on a qualified covenant, an application for consent to a change of use on a qualified covenant rather than a fully qualified covenant. And that could legitimately have been done. And there are other steps, we say, that would also have more obviously been taken if the landlord was concerned about enfranchisement. So, under the legislation currently, it relates to a building. It's got to be a house reasonably so called, but it's a building. And at present, one could carve out the roof and all the foundations so as to take the building outside of the Act.
I mean, the issue is not whether you could do it in other ways. The issue is whether they've done it successfully in this way. And I'm not quite sure what the point is.
Yeah, well, I do take that.
Ingenious drafters can do all sorts of things.
I do
but as a
take-
basic principle, you can't contract out of the 1967 Act.
Yes,
So one would have to get over that problem. But
yes.
no doubt the ingenuity of you and Mr. Rainey could come up with all sorts of clever clauses. But we're dealing with this one.
Yes, I entirely accept
And if
that.
one of the effects of being able to refuse permission to change residential use is that the landlord gains an extra protection, what's wrong with that?
Well, my lord, our point is that had the purpose of the clause, had the intention of the parties been to enable the landlord to deploy clause 319, to cut down the residential use, entirely to negate, in fact, the
I mean,
residential
why do you have to
use.
see it like that? I mean, you've got section 319, which simply gives the landlord a right to refuse permission. Now, there's nothing which limits his grounds. He's not limited to planning grounds, is he? As far as I know, he can do it on any grounds which are relevant to protection of his property interests.
Well,
And if he does that, why should we? What's the problem?
in our submission, he ought to be limited to planning grounds, because if when one's looking at the purpose of the covenant, and you're looking also at the harm that the landlord anticipates that it's going to suffer, is this a type of harm that the parties contemplated the landlord should be protected against by deploying this clause? In our submission, it can't be so wide, clause 319 can't be so wide as to encapsulate anything that the tenant, any harm that the landlord perceives it might suffer. One does have to look at the express provisions in the lease, particularly those which make a grant. So where one has a grant, an express grant of permission to use for residential purposes, one would be construing clause 319 as trying to live alongside that, but if it can't live alongside that, then it has to yield, because it's a general provision relating to the reasonableness of the landlord's concerns.
Well, yeah, I mean, you've got one point, which may be good, may be bad, but it is that you can't use 319 to cut down what you say is implicit rights granted by 311.
Yes.
But I mean,
So there has so
that's all
reasonableness.
it is. It's not.
Reasonableness isn't at large. It's not something
Yeah.
that has no limits.
That depends
whatsoever.
not on the construction of 319, but the construction of its relationship with 311, which you say have to be read together, and I understand that.
Yes.
That is your point, isn't it? And the other point.
That is one of my points. The other point I was seeking to make is that the landlord could have drafted the lease differently had it been concerned to prevent the tenant from gaining enfranchisement rights. There are many
No,
more
I
obvious
understand
things.
that, and for my part, I wouldn't have any doubt there would be other ways it might have done, which would not have ended up in the Supreme Court, but we have to deal with what it's done, unfortunately.
Yes, but in our submission, looking at the other ways that the landlord could have gone about this exposes the weakness, exposes that it can't have been contemplated by the parties that under clause 319, the landlord could turn round and on day one of the lease say to the tenant, I object to you using the premises for residential purposes. Had the parties in 1986 had this discussion on day one or day two of the lease, I think the tenant would have been very surprised to learn that the landlord considered itself able to give with one hand and take away with the other. However, whether it's derogation from grant or uncovenanted advantage or the purpose of the clause, whichever way one looks at it, the landlord would have done many other things if that had been its intention. It didn't do those other things. So it wasn't trying to prevent enfranchisement. It wasn't trying to protect itself at that point. That may have missed a point. It may have made a mistake, and it may now regret that that is the case. But in our submission, that doesn't assist.
So remind us, if 319 cannot be deployed to refuse consent for a planning application of this sort, what is left of the landlord's rights under 319?
Yes, my lord, I will come on to deal with that next. May I
Good.
just finish my submission?
Of course you can.
In relation to the other provisions that the landlord could have made under the lease. Just to make one specific point, there was no restriction imposed on assignment, and I'm sure the court has this point. But although the original tenant wouldn't qualify because it was a company, it couldn't meet the residence test, it could freely assign to the tenant a tenant who could on day one.
Yes, because initially I think the tenant had to be an individual,
Yes.
not a corporation.
Yes.
And you say, well, if the landlord couldn't rely on the tenant being a corporation, therefore outside the initial the initial scope of the Act, because there is absolutely no restriction on assignment until the latter years of the lease.
Exactly, my lord. And the best advice that the landlord could have got at this in 1986 was, well, if you want to prevent enfranchisement, you need to prevent a tenant coming in who's able to enfranchise. You may have a company now, but you've given them the ability freely to assign the premises to an individual who could come in and take up occupation. And the upper two floors of the premises were already in residential use, so an individual could have come in and taken up residence in those two upper floors. Now, whether or not that would have enabled it to enfranchise when the rest of the property wasn't used for those purposes can be debated. But the one thing this landlord would have done, had it been concerned to prevent enfranchisement, would have been to prevent assignment.
Did you have to pay a premium when you took the lease?
Yes, so there was it's sort of a peppercorn rent, and there was a premium that was paid at the outset. And I assume, although I don't know the details, when my client took an assignment of the lease, it would have paid a premium, and it would have done so based on thinking that residential use was a permitted use. And in our submission, any tenant would be rather surprised to learn that the express grant at clause 311 could simply be cut down by a consent provision, a wide consent provision, in a different clause, in a planning clause. So any tenant, on the appellant's submission, any tenant coming in to look at this lease and decide whether or not to pay the premium should not just be looking at clause 311 as what's permitted, but should look at any other provision in the lease that requires the landlord's consent to be obtained.
Yes, but it's not just a case of residential use being prevented. The effect of what you are proposing is that the landlord will be liable, on the assumptions we're making, to a claim for enfranchisement, which wasn't there before. Now, if there was some kind of obligation that one sees in different systems about not abusing rights, it might be said that this was an abuse of rights because it was taking something which the parties, was not, you're not just going for planning permission, you're going to planning permission to position yourself. That's what's being put to us.
Yes.
To enfranchise. So it might be said that's a breach of a good faith use of the right or something like that.
But, my lady, that isn't a point that's being taken against us. And in our submission, the tenant's motive is not a relevant consideration. Our motive for wanting to use the premises for the permitted purpose is not a relevant consideration. The landlord's motive is relevant because that plays into the collateral advantage point. But there's no converse principle that the tenant's motives have to be pure. But in any event, we would say exercising or seeking to exercise a right given by statute could not be an impure motive. It's seeking to exercise a right granted by Parliament.
Yes?
My Lord, just to complete this section of my submissions, you will have seen that the Court of Appeal recognised that any person can apply for planning permission. So, in our submission, how likely is it that the landlord would have in mind using this particular covenant as the only way of preventing residential use, giving rise to an enfranchisement risk, when any proposed assignee could make such an application? They could make a planning application before committing to taking an assignment. They might do that. The tenant wouldn't be suffering or permitting that application to be made if the proposed assignee simply wanted to establish whether or not it was likely to be a lawful use as far as the planning authorities were concerned. So if that assignee, that proposed assignee...
Why would a third party unconnected with you have any interest in making an application of that sort?
My Lord, the point that I'm making is that a proposed assignee of the lease may wish to make such an application. So if they're seriously proposing to take the lease, they may wish to make the planning application before committing to do that. But I
didn't know that your aspiration was to assign.
Not in these particular... My client's aspiration is not to assign.
No.
But the point that's being made by the Court of Appeal and that I'm making is that this clause 319 is precarious, because if the landlord wants to prevent residential use leading to enfranchisement, if my client were proposing to assign, the proposed assignee could apply for planning permission to turn it to residential use. And as long as my client doesn't aid and abet, doesn't suffer and permit that application to be made, then that is a route through. That would be entirely to undermine the covenant.
I find that difficult because you're envisaging a context where someone is wanting to obtain an assignment of the property and presumably would have spoken to the tenant of the property to see whether that tenant was thinking of an assignment and would go through the terms of the lease, presumably in discussions with the sitting tenant, and would realise that there was a restriction on planning permission. It seems to me that it is at least arguable that in such a scenario the sitting tenant would be aiding and abetting or suffering the application to go in as part of the arrangement of the assignment. I mean, what the Court of Appeal looks at is a stranger coming along and doing this. I mean, would a stranger be a realistic scenario?
Well, my lord, a stranger, I suppose, could be a realistic scenario if... I'm going to come on now to deal with Lord Wilson's point about whether Clause 319 is a dead letter, and that's going to take in a submission that there may be circumstances where you have specific permitted uses in the local authority's area, and it may be that there's only two cafes that are able to be next door to one another, that sort of provision. And it may be that a stranger would want to apply for planning permission on these premises in order to get planning permission for a cafe use so as to restrict competition.
Well, but so what? I mean, I find this bit of the Court of Appeals judgment rather odd because, you know, it may be that in theory a stranger could apply and maybe
Yes.
wouldn't be caught by this clause. And if so, then the clause may be defective in that respect because it's clearly designed to stop people applying for planning permission in circumstances where the lessor doesn't want them to. And it may not be perfect, but we have to deal with the case before us, which is where you're applying for permission and you're undoubtedly within the clause.
Yes, my lord, yes. And the point I'd seek to draw from it is it bolsters my submission that a landlord wanting to prevent this tenant from enfranchising wouldn't leave all of these holes exposed.
This goes back to what I was saying a few moments. You know, most of the cases which get to us because there's something defective in the terms, and if the people had done a better job drafting their agreement, they wouldn't be here. But We have to deal with the cases before us.
Indeed, my lord. But this isn't a case where there's some ambiguity, where there's been a mistake in the drafting that the court's being asked to construe. We're construing two clauses in the lease that have been properly drafted, and one has to yield to the other in our submission. But I take your lordship's point. I'm going to move on to deal with
Yes, very
Wilson's
well.
point about whether the planning covenant is a dead letter.
I think that's para 55 of
Para
your
55
written
of our
case.
submissions, yes, my lord. That's at page 162 of the core bundle. So I will just follow those submissions by and supplement them by a couple of points. Now, this isn't an exhaustive list by any means. We have set out what occurred to us as being some potential applications that we considered worth raising as part of our submissions. There could be further changes in the planning law that obviously we can't foresee. And in our submission, there's no reason to establish definitively all the purposes for which Clause 319 could be used. And as the Court of Appeal recognised, it's far easier to establish what Clause 319 isn't designed to be used for, rather than all its potential applications. But what we have sought to do is to draw your lordship's attention to three particular points. The first point is the landlord might object to an application if it anticipates that it's going to incur liability as a result of the proposed development, whatever that development may be. If it's going to incur liability, it is going to wish to retain some control over the making of planning applications. And conditions are very frequently attached to planning applications, to planning permissions. And we refer to the provisions of the Town and Country Planning Act in that regard. I don't know if the court wants me to take you to those provisions. We have, I've summarised them. So there's the Town and Country Planning Act that was in force in 1970, from 1971 onwards. It was in force at the date of the lease, and it's the same as it is today. They do provide for the owner of the land or any person having any interest in the land to be served with a notice of a breach of planning control. And so, in these circumstances, the landlord could find itself on the wrong end of an enforcement notice if the tenant doesn't comply with the planning conditions.
You might want to excavate the basement, and it might turn out to be unsafe. A situation in which the landlord might wish to come in and legitimately
yes,
say,
indeed.
I have lots of conditions in there, please, about engineers being instructed to advise.
Yes, yes.
But wouldn't that be a structural change that you need consent for under some other area of the lease, Miss Scott?
Yes, my lord, that's quite correct. So I'm going to come on in a moment just to deal with the alterations and how the alterations covenant would...
Very well.
When I just finished my point about liabilities. So the second point that we raise is about the community infrastructure levy. Now, that's something that's been introduced recently. It's another example of a way in which a freeholder can come under liability as a result of what the tenant does by way of development under a planning consent. And again, I don't think I need to take you to those provisions. We've given the citation. So, my Lord Wilson's point, I'm going to take that next. The landlord could take issue with a planning application that seeks permission for carrying out some alterations. There might be external alterations, any structural alterations. There might be alterations that give rise to overlooking or rights to light, which is the sort of thing that one might envisage being caught by the planning covenant. Now, structural alterations do need consent under clause 3.9 of the lease, but that is itself, it's a fully qualified covenant. So this is an alterations covenant where the tenant has to seek the landlord's consent. So there you would be construing alongside one another two fully qualified covenants. So that's not the situation that we're dealing with here. The tenant could legitimately argue that if the landlord's objection doesn't relate to the structural elements of what it proposes to do, it relates to some more of a planning aspect, such as overlooking, or it might relate to the landlord's estate, the wider estate. The landlord might want to secure its position more fully than simply having the alterations covenant, because the tenant might legitimately say, well, this is a planning concern that you're raising. It's not a structural concern, and therefore it doesn't fall within the purview of clause 3.9. So we say that's another situation where clause 319 might be deployed. And the third point that we raise is that the tenant could seek to make an application for a change to a lawful use, one that's not permitted under the lease. So something that's not permitted under this lease, for example, is cafe use or restaurant use, takeaway use. Now, there could be other reasons why the tenant might want to make such an application, but we've picked one example where the local authority, as I was saying a moment ago, might have limited the A3 or A5 uses, the cafe uses, to a particular area, and the tenant might want to take up one of those limited permissions to prevent adjacent properties from being turned to that use, if it might object to that on grounds of amenity for its residents or its tenants. And we've given an example of how that might work from the local plan of the London Borough of Newham. And again, I don't think I have to take you to that unless you would like me to do so.
No, thanks.
So I just make the point on this topic of which covenant is a dead letter. On the appellant's own case, clause 319 is rendered a dead letter because the possibility of a change of use to residential use has been ruled out for the foreseeable future. So clause 319 is a dead letter as far as changing the use of the premises to residential use is concerned. The landlord is saying it's not going to grant permission to change use for the foreseeable future. And so clause 319 is useless to the tenant in those circumstances. So on the appellant's own case, it's a dead letter. My Lords, I've got two other topics to deal with. The first is distinguishing the enfranchisement line of cases, so Bickle and Kitway. So I'm going to deal with that relatively briefly, and then I'll come on to deal with Section 10, which is my final point. So looking at, I'm going to call them the enfranchisement cases, so I'm talking about Welch and Bahrain, Bickle and Kitway. Now, in our submission, those can be distinguished from our case. In the enfranchisement cases, the court wasn't tasked with construing these two competing covenants. It's not a point that arose for consideration. It wasn't construing the consent provision alongside a dispositive provision. And in the enfranchisement cases, the refusal of consent didn't render any other right in the lease nugatory, so there wasn't this question of derogation from grant. The right to assign was expressly agreed to be limited, so it's expressly stated in the assignment clause itself that you've got to get landlord's consent to a disposition. And on the facts, the courts concluded that it would be reasonable to refuse consent where the tenant wants to bring itself within the Act. Now, by complete contrast in our case, there isn't any restriction agreed on the right to use for residential purposes. So the consent provision is in an entirely different clause. And the effect of being able to refuse consent isn't just to restrict or constrain the tenant's rights, it's to neutralise them, neutralise the expressly granted rights for the foreseeable future. And in our submission, in these cases, the court was the court's decision was reached on the basis of the personality of the tenant, because what was being dealt with was an assignment from a tenant who didn't qualify under the Act to a tenant who could qualify under the Act. And the court in Bickle thought, well, that falls squarely within the Holder and Gibbs principle, that you're looking there at the personality of the assignee.
Well, that's one way of describing it. Another way would be the risk of enfranchisement.
Yes,
the risk of enfranchisement because the assignee would be resident or
yes,
whatever.
So the risk of enfranchisement is the harm that eventuates
Yes.
from the assignment. But it's the reason why it was found to be reasonable to refuse consent was because you're looking there, it's the personality of the assignee. It's an assignment, for example, from a company to an individual. It's the personality of the individual that makes it reasonable to refuse consent in those circumstances, because they can take up the enfranchisement rights.
Yes,
Yes.
right. Yes,
My Lords, if we could just go back to Bickle, which is Authorities Bundle 1, Volume 3, sorry, Tab 3. If I could just ask you to turn up page 369 in the electronic bundle. It's page 41 of the hard copy bundle. And we're looking at between D and E, and these are the submissions that were being made by counsel for the landlords. And this is where, this relates to what I was saying a moment ago about the personality of the lessee. The submission was made that the objections were to the personality of the lessee themselves, being individuals and not a company, and the proposed user. And there, what's being said is the proposed user is occupying and not holding as an investment. So these cases aren't looking at the user as residential use. There wasn't an objection taken on the grounds of residential use. The objection was you're going to be occupying the premises as a residence rather than being a company that's holding the premises as an investment. So, my Lord, I know that you're familiar now with Lord Denning's formulation of how one must look at the terms, one must look at the circumstances of the case because they're infinitely various, so I won't take you to that. But each of these judges reached their conclusions based on the personality of the assignee, and it fell squarely within the Holder and Gibbs principles. My Lords, if I could ask you to look at Kitway, Norfolk and Kitway, which is at tab 8. So Holder and Gibbs wasn't referred to in the judgments here. Now, what the court seems to have been grappling in Norfolk and Kitway with this distinction between normal and abnormal assignments, which came from the Rent Act cases. So when there's an assignment of the lease at the fag end of it, in that colourful phrase, at the tail end of the lease, if the purpose of the assignment is specifically to confer statutory rights on the incoming tenant, then it would be reasonable to withhold consent. If the assignment is earlier in the lease, then that could be a normal assignment, and it would be unreasonable, therefore, to withhold consent. So the court here in Norfolk, the reasoning is quite different from Bickle. And the strong desire of all three judges seems to have been to avoid having to apply this abnormal-normal distinction found in the Rent Act cases. There's no suggestion here that the landlord's objection was based on residential use per se or on change of use. What's being said again is that because the incoming tenant is an individual person and therefore could qualify enfranchisement, that is a reason for refusing consent. So that does come within the Holder and Gibbs principle, although it's not quite reasoned as such by the judges. But Kitway is rather light on reasoning. There seems to have been a visceral reaction to the case following the passing of the 1967 Act. And as I say, the judges are grappling with this abnormal normal distinction, which was then subsequently disavowed by the court in West Leighton. So we say again, this is not a case that approaches the task that's before this court now, which is to try and construe these two inconsistent covenants, where the landlord's objection is based on residential use per se.
Yes.
My Lord, Section 10 is my final point. We deal with this in our submissions at paragraph 66, and that's at page 168 of the core bundle. So your Lordships have the point, I think, that this point stands or falls with the appellant's case generally. Now, in our submission, the appellant's case does overstate the harm that would be suffered on enfranchisement. The reversion isn't extinguished, as is submitted, nor is it damaged. It's bought by the tenant for a fair market value. It's converted into money. And within this enfranchisement objection, it's stated that the appellant will be deprived of estate management control of the block that it owns. But that doesn't recognise the protection that's afforded by Section 10, we say. And I think your Lordships have the point that Section 10 relates to restrictive covenants that can be included in the transfer of the freehold to protect other property that's owned by the landlords. And it's only if those materially enhance other property that they're relevant. If they don't materially enhance, then there's, in our submission, no harm to the landlord by not having control over the relevant aspects. So provided they materially enhance, then they will be included in the transfer.
I mean, we know that on this point, Mr. Rainey doesn't think he can succeed if he doesn't succeed on the main point. So, and we've got your points in your submissions.
Yes. So, my Lord, the main point that we make is that this is a decision on the facts. That decision was taken by the judge at first instance, having heard the evidence, affirmed by the Court of Appeal, and it would be very unusual for this court then to go behind that, is our main submission. My Lord, you have our submissions on the good working rule. We've put those into an appendix, and I don't propose to go through those. I'm sure you've read them, and we'll read them again. My Lords, is there anything else I can help with?
It seems not. Ms. Scott, thank you very much indeed.
Thank you.
Now, Ms. Black, are you going to follow? Very well. Mr. Rainey.
My Lord, I'll bear in mind your Lordship's observation this morning about not deliberately taking up all the time available, so I'll be as quick as possible in my response. And just, I obviously have to dot around slightly, but dealing with the sort of key big points of principle. One of the first points which emerged during Milan Friends' submissions was there's a question about how much of what's said in Bromley Park finds its way into international drilling and how much from that finds its way into Ashworth Fraser. And in my submission, in international drilling, Lord Justice Balcombe doesn't adopt the specific formula which was set out in Bromley Park. What he said was that Bromley Park was an example of a recent case. That's all he said. And so in my submission, you can't read the passage from Bromley Park, which was discussed this morning, into Lord Justice Balcombe's judgment. And it doesn't, therefore, find its way into Lord Bingham's speech in Ashworth Fraser. What does find its way into Ashworth Fraser is the key passage from Bickel or Bickel. Milan Friend is right. What Lord Justice Roskell said about it in West Leighton isn't an accurate description of what was said in Bickel. In fact, I would go further and I would say it's actually contrary to what Lord Denning actually said in the passage which was recited at length by Lord Roger in Ashworth Fraser. The next point I wanted to address was there are various points which arise in respect of the series of covenants and the word yield. I would submit that the problem which apparently arises with Clause 311 yielding to Clause 319 or 319 yielding to Clause 311 is because it starts from the false proposition that Clause 311 is a grant and the other clauses are derogating or restricting that grant. None of them is a grant. And if one starts with the proposition that they're simply three separate restrictive covenants, then the yield point doesn't arise at all. They each, and when I say the three of them, that's 311, 315, and 319, in their different ways, they each restrict the use which can be put, to which the building can be put by the tenant. The starting proposition being that a lease which has no tenant covenants in it doesn't restrict use except for the implication that the tenant won't use it for an illegal or unlawful purpose. So that's a starting proposition. Tenant can do what he likes. 311 restricts it in various ways. 315 restricts it in different ways. And 319 restricts it in different ways. And so that is the answer and the very straightforward answer to the yielding point. And as to the question about authority, I would simply say that I don't need authority for the basic proposition that when construing a contract, you give effect to all of its terms, so far as one can. And if you treat them as all being restriction and restriction and restriction, there's no difficulty in so doing. As a corollary to that, I therefore would not accept the proposition that a properly advised tenant would be surprised to be told that Clause 319 prevents the first and second floors from being used for residential purposes, because Clause 319 begins by saying you may not use the property for any purpose which is not permitted by the Town and Country Planning Acts. Any solicitor doing due diligence on that lease before a purchase would write a report on title which would say these are the current permitted uses under the Town and Country Planning Act. Here's the extract from the planning register, and indeed those are the current uses. If you wish to change the use, you'd need planning consent, and you'd need the landlord's consent for it. So I wouldn't accept that the properly advised tenant would be at all surprised, as my learned friend suggests, by the submission that I make. The third point, which can be added into this series of points about how the covenants are construed, is the point about whether or not there is a collateral advantage being sought. With respect, that argument is circular, because it's only a collateral advantage on my learned friend's case if one presupposes that the landlord doesn't have the right already, and the landlord only doesn't have the right if it is not able to refuse consent. So it simply begs the question which it seeks to answer. It starts from the proposition that consent can't reasonably be refused, whereas I start from the opposite proposition, which is that the clause says that consent may be refused if it is reasonable, and on that basis, simply reasonably refusing consent. So
the clause to give your consent to planning applications doesn't look like an obvious candidate for preventing a right to enfranchise being obtained. It just seems very indirect.
That is, I would respectfully submit, I would say that is falling into what I say is the trap that the Court of Appeal fell into, which is to ask or to pose the wrong question, because the purpose of the covenant is to restrict planning applications if they're going to cause damage to the landlord's interests. Now, enfranchisement, I say that enfranchisement is simply a species of damage, and it doesn't have to be a species of damage which is specifically contemplated necessarily by the parties.
But then the answer given to that is that it's only a question of motive. And we know from cases like Bradford Corporation and Pickles that it's motive, it doesn't disqualify you from exercising your right.
No, but it's the way the cases have been put, it is the proposed use of the premises. And I would say that enfranchisement is not a tenant motive. It is a proposal to which the tenant wishes to put it's a use effectively of the premises. It arises out of, in this case, not the actual use, it's the lawfulness of the use to which the tenant would be able to put the premises. I mean, it probably is a very fine distinction which doesn't matter, but the damage in this case actually would flow from the lawfulness of being able to use the first and second floors of residential. They wouldn't necessarily actually have to go and do it, because the enfranchisement, on the state of the case law, it appears to be it's the lawful use, not necessarily the actual use. That might be a thin distinction, but the damage flows actually from the getting of the planning consent. And one might make the same point about covenants against assignment. Is a covenant against assignment a particularly logical or obvious way to restrict the use of the premises? Well, no, it isn't. But there are numerous cases where it has been held reasonable to refuse consent to assignment on the basis of the proposed use. And what is the principle which underlies it? And the principle which underlies it is the one that one takes the circumstances as they are at the date of grant. At the date of the application for consent. And one might, to take the Faulkner case, Bridewell Hospital and Faulkner, that's an open user case. The objection is that it's going to be assigned to General Booth for the Salvation Army, even though General Booth actually says, if one reads the report, he says that he effectively promises that he's not going to use it for band practice or meetings, he only wants it for officers. But be that as it may, the existing tenant, could presumably have joined the Salvation Army. The existing tenant could have found religion and started to use those premises for band practice and public meetings, because there's nothing in the user covenant which prohibits it. But the point is, he's not doing that. The fact of the case is that that's what the assignee is proposing to do. And if that is the case, and the landlord can say, well, that will damage my interests, then the landlord can reasonably object. In a way, it's the same point about the officious planning applicant, the third party who comes along who has nothing to do with the tenant and says, well, I might apply for planning. Bluntly, so what? If they do, they do.
But in Bridewell, and you correct me if I'm wrong, the landlord didn't know about General Booth lining up to take a possible assignment at the time when he granted the lease.
No, I accept that. Which is one of the reasons why the control is reasonableness, because that allows for all things foreseen and unforeseen to be taken into account, as long as they will damage the landlord's interest. But I'm sorry.
No, I didn't want to stop your sentence. Sorry.
But the point I was making is that the tenant could, on the facts of it, said, well, I'm not going to assign to General Booth, I am going to join the Salvation Army myself. But that doesn't prevent the landlord from being reasonable when the actual facts in front of the landlord are that it is the assignee who proposes to do that. And it's a species of the overriding point, which I would say is probably within the second of Lord Bingham's principles, that it's a question of fact. What he's really getting at is it depends on the particular circumstances at the particular time.
Yes, but as again, my point was that could it not be said that the landlord had taken the risk when he executed a lease knowing of the 1967 Act?
Well, the answer to that is, and this is an important point, the premises didn't qualify. They didn't qualify in 1986. They didn't qualify last year, and they don't qualify now. So even if, and this was put, well, it could have been assigned to an individual. Well, yes, it could, and that individual wouldn't have had any rights either. As it happens, the law moved on, and the company gained the rights which individuals used to have, but it didn't do the company any good.
Yep.
And so it's simply, again, I would submit it, if one stays grounded in principle, take the facts as they are at the time, and at the present moment, getting this planning consent would, as the judge accepted, give rise to a significant, there's a material increase in enfranchisement prospects, to put it no.
Yes, thank you.
And as to the point about the bargain and regretting the bargain, which is another point my learned friend made, again, I submit that rather begs the question. I would submit that on this case, it is in fact the tenant who would regret the bargain, because the tenant entered into a lease by which they said they wouldn't apply for planning consent without the landlord's prior written approval. So it begs the question as to what the bargain is. And I say the bargain is a contract. The contract includes all of its terms, all of the restrictions on use. And that is the short answer to that point. Lord Justice, my learned friend referred you to Iqbal. What Lord Justice Peter Gibson was saying in Iqbal, in the passage, I mean, she read it out, but in fact it's one of the things which is actually set out in the table in my written case. It's not enough that it's a permitted use. Because what Lord Justice Peter Gibson says,
Where should we look at this from?
probably the easiest way to find it, my lord, is to look at the table in the appellant's case, which is
Yes.
at pages 98 to 99.
Oh, yes.
And Iqbal is the central column.
Yes.
And what Lord Justice Peter Gibson said in 26.5, having said that it may be reasonable to refuse consent for a purpose, for a proposed use, even if not forbidden. And then he goes on to say, whether such refusal is reasonable or unreasonable depends on all of the circumstances. For example, it may be unreasonable if, and there are two things here, I submit they have to be read together, if the proposed use was a permitted use and it's crucial in my submission that what follows the and, the intention of the tenant in acquiring the premises to use them for that purpose was known to the freeholder. So it's not good enough that it's within a category of permitted use. What Lord Justice Peter Gibson is saying is that you've got to know that the tenant actually is going to use it for that particular use. And that is the background to the paragraph at 42, which my learned friend specifically read out to your lordships. There were specific findings in that case that A3 restaurant use was the use for which the tenant was going to put the property, even though the user was completely open. And it's that which sunk that particular argument of the landlord, that specific finding of a purpose, not the wide permitted use. Yes. Another point which arose during my learned friend's submissions, going back to the international drilling case and Lord Justice Balcon's judgment, learned friend took you to page 416 of, in the electronic page numbers, which is page 88 in the hard copy. At the bottom, she referred you to what's said there about the case of Leeward Securities and Lilyheath. I would submit that what is said there is entirely consistent with my submissions, because it was, according to Justice Balcombe, it was a subletting which would attract the protection of the Rent Act. And the point is being made is that Lord Justice Oliver and Lord Justice O'Connor made clear that they could envisage circumstances in which it might be unreasonable to refuse consent to an underletting. So first point is, we're starting from the proposition that it's reasonable, but it might be unreasonable if the result would be that there was no way in which the tenant could reasonably exploit the premises except by creating a tenancy to which Rent Act protection would apply, and which inevitably would affect the value of the landlord's reversion. So what's being said is well, it might be unreasonable, contrary to the general run of Rent Act cases, and I would say enfranchisement cases, if it's the only way you can exploit the premises. And this comes back, I would submit, to my learned friend's point about derogation from ground. She simply cannot say that residential use of the first and second floors of this building is the only way to exploit the premises. She has the difficulty that from 1986 to date, they were in a different use. And indeed, there are a whole range of uses which are not prohibited by the restrictive user covenant in clause 311. So one can't even begin to get anywhere near Leeward Securities. And what that shows is that is probably consistent with the narrowness of derogation from grant, which was the point in which was in Johnston, to which I took your lordships this morning. And then I think the last point on which I should come back is the my learned friend's paragraph 55, and the other, whether or not clause 319 is rendered a dead letter and what else it might be used for. If one goes briefly to that paragraph in the respondent's written case, which is at pages 162 and 163. There are a couple of points. The first is this. This doesn't get away from the point that the subject matter of clause 319 is, by definition, the subject matter of other covenants. Planning covers development, which is use and alteration, and the lease will have a user covenant and an alteration covenant. So it doesn't help my learned friend with what I would say is the problem that her submission faces, which is that if you say, well, that the user covenant, if the user covenant doesn't prevent you from carrying out or entering into a particular use, then you can't rely on the planning covenant. The same could be said of the alteration covenant. Unless the alteration covenant prohibits or restricts it, it is no business of yours looking at the planning covenant. So these set of examples can't deal with that point. The second reason that these set of examples can't help is that, take for example the point about the her example A. He says, well, there might be a fear on the part of the landlord that the tenant might commit a breach of planning control and there could be enforcement against the landlord. Or example 1B, community infrastructure levy. She says, well, the landlord might want to make sure that community infrastructure levy is paid only by the tenant. But it's implicit in this argument that consent is being refused or withheld. So if the use is permitted under 311, but the planning application will trigger community infrastructure levy, what she says is, well, in those circumstances, the landlord can either refuse consent or grant a conditional consent only. But as I understood her submission, 311 says, but you can use it for X purpose. So we really come right back to the point that the two covenants overlap. Because as I understand it, my learned friend is saying that if the consequence of the planning consent is that community infrastructure levy would become payable, then it would be reasonable for the landlord to refuse at least an unconditional consent, even though the use is permitted. So clause 311 can, on her own case, override what she says is a grant in 311. The example too about alterations, as she says, there is a qualified covenant against structural alterations in the lease already. I don't understand how, as she puts it, 319 gives the appellant a more secure method of objecting to proposed alterations on the grounds, for instance, of overlooking or loss of rights to light. I mean, if it's not reasonable under the alteration covenant, how can it be more reasonable under the planning? And then example 3 doesn't really arise because it seems unlikely that a tenant would apply for a change of use under 319, which was specifically prohibited. The better example would have been to say, what if within, for instance, retail, there were different use classes, and the local authority in its local plan said you can't have, I'll pick the current use of the property, which is ironmongers. Let's assume it was a different kind of shop. The local authority had a rule that you couldn't have more than one ironmongers on a street, retail to retail. Apparently, my learned friend would accept that if changing it to an ironmongers would have an effect on the landlord's other properties in the row, then it would be reasonable to refuse consent. But that's within the permitted use under the lease. So none of these examples really assist my learned friend. None of them are a problem if your lordships were to accept my submission that 311 isn't a grant. It's one of 3 restrictive covenants, and that you simply give each restrictive covenant its place and apply the 3 sets of restrictions as they arise, as and when. So for all those reasons, and for the reasons I've elaborated this morning, in my submission, this is a relatively straightforward case. The touchstone is reasonableness. Reasonableness is not confined narrowly as the Court of Appeal sought to do so, which is, I would submit, inconsistent with principle. And although perhaps it goes too far to say harm is a sufficient condition, which was the charge that my learned friend made a little earlier, perhaps the way to put it is, it is a sufficient condition provided that it is harm which arises out of the landlord and tenant relationship, which is the first proposition in Ashworth-Fraser, and provided that the supposed harm isn't in reality seeking to achieve some advantage, as in the harm is not getting an advantage, the uncovenanted advantage point. But provided you don't trespass into outside those 2 principal parameters, then actually harm is a sufficient condition. It is the condition.
You'd have to allow, presumably, a little exception of disproportionate impact on tenant. Not that that applies in this case.
either disproportionate impact on tenant or possibly the derogation from grant point, which perhaps is the same point, because you certainly couldn't have a derogation from grant unless you frustrate the purpose. So perhaps, yes, there is a third overriding principle that it can't offend that basic proposition of law or that basic fair dealing. But as your lordship says, and I respectfully adopt that point, there can't be any question of it on the facts of this case.
In opening, I think you said harm wasn't entirely sufficient because you had to see whether it was harm arising out of a change from or preservation of the status quo.
Yes, as long as we don't trespass into an uncovenanted advantage, yes, which means going beyond the status quo, trying to improve your position on the status quo. So yes.
So you can't rely on a harm in not being able to. It's got to be a harm that arises from a change from the status quo.
Yes, I mean, another way of putting it is that that's not really harm at all. That perhaps a clearer way to put it is to say that when we talk about harm or prejudice, that must mean by reference to the status quo and not by reference to some imagined state of affairs to which you would like to arrive. So yes, my lord. My lady, is there anything further?
Mr. Rainey, we didn't hear much from Ms. Scott on Lord Bingham's second proposition, which was whether the landlord's conduct was reasonable or unreasonable will be one of fact to be decided by the tribunal of fact. You did touch on this earlier in your opening, and you said it was an evaluation, and I'm sure that is right. Didn't Judge Colander, in fact, weigh all the relevant considerations that you had so articulately put before him?
He may have weighed the relevant considerations, but he didn't weigh them on the correct, in the correct contextual basis, or to put it another way, he took into account matters which he shouldn't have. In particular, he assumed that the purpose of the covenant was a very narrow one, the purpose of the planning covenant. He said in his judgment that, in fact, I did make a little crib note of where he went wrong.
Well, paragraph 61 is his interpretation of the covenant, and you say that's simply a legal error.
Yes. There are four things I want to... First of all, it's taking too narrow a purpose. It's purporting to limit it by species of damage. It ignores the point which I've made, which is that planning always narrows the permitted use. And it's contrary to the passage in Bickle, which was approved in Ashworth, that the contractual limit is reasonableness, and reasonableness is not to be limited under the guise of construction to some narrower purpose. So there are four things wrong with the first.
I'd like to note these very quickly, please.
In bullet points, it's too narrow a purpose,
Yes.
319, purporting to limit the purpose by reference to the species of damage, ignores the fact that planning restrictions always narrow the permitted use, and ignores the proposition in Bickle and Ashworth that reasonableness is not to be limited under the guise of construction by some method of construction as referable to what is said to be the purpose or contemplation of the original covenant.
But if they were right about construction, it wouldn't be under the guise, would it? I mean, Lord Denny's use of guise means, doesn't it, an illegitimate recourse to construction?
Yes. Those are the first 5 lines of 61.
Yeah.
Then the last lines of 61, he says it's unreasonable because they're seeking to achieve a collateral purpose. In my submission, he has the law on collateral purpose wrong. So there's actually an error of law there. and there is no advantage sought because my client is simply seeking to preserve the status quo. Paragraph 62 is shot through with two problems. The first is the point of controversy between myself and my learned friend about whether or not it's inconsistent, as he puts it, with Hautford's right to enjoy the property for the term granted, which includes the right to use it for residential purposes. This is the hierarchy of covenants point, and I say that he and the Court of Appeal and my learned friend are wrong in effectively, as my learned friend puts it, treating 311 as a grant, and not in effect giving effect to all of the covenants, when they're all part of the bargain. If, as my learned friend would now characterise it, this is getting at derogation from grant, then it's wrong for that reason also, because there is no finding of a specific purpose. If you use the user covenant restrictions as the basis for divining purpose, then you have a very wide purpose, and you can't say that the purpose is frustrated by refusing consent to the use to a planning application to change the use of the first and second floors to residential. Paragraph 63 is wrong for a number of reasons. First of all, it's wrong to say that there is a difference between pre- and post-act cases. The true principle is one of damage, and that there will be damage which is within the purview of any consent covenant if at the time that the application is made, then the relevant act does not confer rights on the tenant. That's the true principle. And he's, with all due respect to Judge Collender, he's done me a disservice in my good working rule argument. I never said at trial, or indeed in the Court of Appeal, that there is a principle that enfranchisement is always a reasonable ground. I do go so far as to say it is usually a reasonable ground. And I would submit that I'm right about that, and that the judge was wrong.
Well, that's very helpful. Thank you very much.
I had some other, because, well, there are other points, but paragraph 64, it falls into the collateral purpose, misapplying the collateral purpose or uncovenanted advantage rule again. Paragraph 65 refers to the fact that there could have been an assignment to an individual, but although the judge does record this fact, he doesn't seem to have recognised that he says the individual could have converted the whole property to a residence, subject only to planning permission and the lessor's consent. Well, I mean, that's the circularity point. They couldn't have done it without the lessor's consent. And
So you're back at square one.
You're back to square one. And in saying that there should have been other ways in which the lease was constructed, he's effectively been bamboozled by the mixed-use context. The Rent Act cases, and Bickle and Kitway, and so on, they are cases where the property is a residential property. It can't sensibly be said that the way to avoid enfranchisement of residential properties is to prevent people living in them. And as my Lord Justice Carnworth observed, I would submit rightly, yes, there are ways in which one can, I'm not sure I'd say they were devious ways, but there are sophisticated ways in which leases can be constructed to try and exclude rights. But if they are, they are. In this case, it wasn't, but there is a consent covenant which stands squarely in the way of the tenant.
Thank you, Mr. Rainey. We've got to rise promptly now for various reasons. So it remains for me only to thank both leading counsel and both juniors and the solicitors for all the work they've done in preparing for this, and we'll reserve our judgments